Well, welcome everyone to the first court conference of the Family Resolution Specialty Court. I am Judge Fidnick, and we're here today to have everyone meet me. And first of all, I'd love to know if you have any pictures of Tori, your daughter. Oh, that's great. Thank you. Do you have any?
I do have one. Yes. Oh, this is a very nice picture, yes.
Oh, yeah. That's what she wanted, a big skating competition that you went to.
I did.
Yes.
It's great. Has everyone seen pictures of Tori?
Yes.
Yes, okay, great. What I'd like to do is, if you wouldn't mind, is go around and everyone introduce yourselves. Tell me who you are and what your role is. Why don't we start with you?
So my name is David Sharp, and I'm obviously the husband in this case and Tori's father. I work in a bank. I'm a bank manager. Kind of boring hours, 7:30 to 4:30, Monday to Friday. And the rest of the time I care for our daughter when I get to see her.
Okay,
And I'm happy to be a part of this process. I hope it helps.
great. Nice to meet you, Dave.
Nice to
And
meet
may I
you.
call you by your first name?
You certainly may. Thank you.
Okay.
I'm Tori's mom. I'm Renee, and married to David, although we're getting divorced. That's why we're here. But we're here for Tori, and we really, really want to make sure that she is going to be okay, because she's been having a hard time.
Okay, all right. Well, nice to meet you,
Thank
Renee.
you.
And may I also call you by your first
Yes, you
name? Okay, thanks. All right, would the other members of the team introduce themselves?
Sure. I'm Gail Perlman. I'm Renee's attorney.
Thank you.
I'm Alan Sharp. I'm Tori's attorney.
I'm Patrick Fleming, the family consultant.
Ron Kaufman, the team coordinator.
I'm Kathy Townsend, the mediator.
I'm Jessica Berrien. I'm David's attorney.
Great. So thank you to Renee and David for choosing the Family Resolution Specialty Court. We're very proud of it, and I know you have excellent lawyers who've explained this process to you. It is voluntary. If you decide you want to go into the traditional adversarial process, you always can. Either of you can do that. But I hope that you stay and work with your team here. I did want to just make sure that you understood one thing, and then I want to hear from the team coordinator about what you've been doing up till now. You will have a lot of correspondence and phone calls and all with all the various members of your team, and they will also talk to each other. But I will see and hear nothing other than your questionnaires that you filled out, anything you file with the court, and then anything that's said in our court conferences. And I want to be sure, because there's so much communication in a positive way in the Family Resolution Specialty Court, that you should be supposed to be reassured that whatever you say outside the courtroom stays outside the courtroom unless you bring it in. Okay? Good. All right. So, team coordinator.
We had our first team meeting, and we sort of went through goals and expectations, and what everybody's going to be doing and helping through as part of this process. And I explained to them that I'm kind of the taskmaster in this case, and I'm just going to make sure that we stay on track. Kathy, as the mediator, is going to be working with them on financial issues, and Patrick, as the family consultant, is going to be working on some parenting issues that they're going to have. We've scheduled some a mediation time and some meetings with Patrick. Alan's going to be meeting with Tori and working with them on issues around with Tori and parenting issues.
That sounds great. And both you, David and Renee, know that, everybody here is here to support you getting to a place that you want to be with respect to Tori and ending your marriage. But if for any reason there's areas where you can't reach agreement, that's my job. I can come in anytime. You can ask for a court conference. And if at the very end of the process you've worked with your mediator, worked with Tori's lawyer, worked with your lawyers, and there's a major issue or a minor issue that you need help with, that's my job. Before you go off to work with the members of your team,
Okay.
I was just going to ask each of you to tell me what you hope to get out of the Family Resolution Specialty Court process, and then also what you hope that the other parent will get out of it, and what Tori will get out of it. If you could just tell me briefly what your thoughts are about that, your hopes.
Well, I really, really hope that Tori can continue in the life she's had. And just because we're not getting along and we're separating and David moved out, that her life is not going to be so disruptive. And, that's my hope. And I hope that this process can help David and I heal, because it seems like he seems to sometimes talk down on me and is really negative. And I'm really hoping that he could learn from this and be respectful. And we could be at competitions together for, Tori, and that she doesn't have to feel bad that we're in the same room.
Communication is, of course, the basis of everything, and that's what the team is here to help you with. So I'm glad you expressed that. David, what about you?
Well, I hope to get similar things out of it that Renee just said, in the sense that I hope that we don't fight too much throughout our divorce process. I like the idea that our child is going to be at the center of things in terms of the team effort to try to help her through this. But we do have some tough issues to work out. And that's part of our problem, is that Renee seems to be obsessed with some of our child's activities and skating and issues that we're having trouble with. So I'm hoping the team can really help us and Renee through those things. I don't think I talked down to Renee, so hopefully this process will help clarify that as well.
Well, it's never easy to go from what was a time of great hopes and dreams when you got married and had Tori to this moment. It's very difficult. And so I think you should be commended for trying a process that will not be as difficult in terms of kind of trying to think of the worst thing you can say about one another. But instead to work to build that bridge of time that you can be together for Tori's skating, graduations, marriage, all those things that are going to be in your lives forever. So I will leave you to the capable hands of your team. Counsel, did you have anything you wanted to add today? Gail? Jessica?
No, I think David and Renee are ready to go forward, and the team is ready to help them go.
We're just hoping to really work on their co-parenting and ability to raise their daughter together, and feeling very positive about it. So.
Okay. Anybody else before we close?
Well, just as the mediator, I'm looking forward to working with them. In the team meeting that we had right before this court conference, I was quite impressed with their commitment to their daughter. Despite their differences, that's something that they share and that we'll build on in mediation.
I'm looking forward to getting to know Tori, to give her a voice in this process, and to help David and Renee through these issues that they're dealing with.
And Your Honor, I think that that both David and Renee are recognizing some of the issues, communication being one of them, and they've been receptive to at least the preliminary tools that I've given them, and we've got further meetings scheduled, and I think they're going to be able to work very well to build a kind of infrastructure for their co-parenting going together.
Well, good luck to the both of you.
Thank you.
Thanks again for choosing the Family Resolution Specialty Court, and I'll see you hopefully in a few weeks. Okay?
Great.
Thank you.
All right.
Thank you.
My name is Linda Fidnick, and I am the first judge of the Hampshire Probate and Family Court in Massachusetts. I am also the first judge of the Family Resolution Specialty Court, which you'll also hear called FRISC. You just saw the first court conference, which is the first time that the judge meets with the parents, with their lawyers, with the members of the team who have been assigned to them. It's a time to meet and greet, and in particular, it's a time for the judge to sit with the parties, not up on the bench in the more formal traditional court. And it's a time to remember that we're focusing on the children, which we do by bringing out pictures of the children at the very beginning. And then my job is to reassure them that this is not going to be an adversarial process, that it's not going to be one where their lawyers are attacking them or the other parent, but instead one where everyone works together to solve problems for their family. Other ways that the first court conference is really emblematic of the whole frisk process is that when I walk in the room as the judge, typically everybody stands. But in this case, everyone stays seated. And the next thing that's unusual is that I address people by their first names. They do call me judge, but I call them by their first names if they're comfortable with it, as well as the members of the team. And this is all to make the parents feel that they are part of the team, because they are. The team, they are the core of it. The other thing that's really important about the first court conference is that it is actually in the courtroom. The judge is not up on the bench, but instead we pull tables together, and there are microphones on it because the meeting is recorded, because it is still a court session. It's just done in a very different way that is much more focused on how the people feel about it rather than how the judge and the lawyers feel about it. What might not have been obvious to somebody just watching the video is that the places where people sit is very carefully choreographed. I sit at one end of the table, and then to my immediate right and my immediate left are the parents, because they are the most important people in the room. Right behind them, from my perspective, are the parents' lawyers. And then the members of the team are all together at the far end of the table. And I want to have the parents feel that they are the ones who I am here to listen to, and that their lawyers are here to support them and to aid them, but not to speak for them. We put microphones around for both for projection and also for recording. We follow basic due process rules so that if there is an appeal, there's a record created and the appeals court can make a decision as to whether what happened was appropriate. And yet another function of the first court conference is for the team coordinator to let me know what's been going on with respect to the mediation process, the family consultants meetings with the parents, any kind of deadlines that we need to address, and an overall schedule. And they do that in the team meeting before they come in, so that I think the idea for the parents is that they're more prepared because they've already discussed much of what they're going to hear from me ahead of time. The role of the judge is a very particular one in the Family Resolution Specialty Court, in that although I am the judge for that team, I don't participate in any of the team conversations or emails. The only information that I get is what I receive from the parents when they fill out their introductory questionnaires, and then any formal papers that are filed with the court. And then what happens actually in my presence and in the parents' presence at the court conferences. All of the other conversations that the family consultant, the mediators, the child's attorney, the parents' attorneys, all of that takes place privately, meaning private from me, so that there's no concern that there's any back channeling of information that I'm getting. The parents know that the only thing that I hear is what they tell me and what they've seen that I see. The other role that the judge can play is while everybody's meeting and they are proceeding with mediation and with the child's attorney getting to know the child and the family consultant working on a parenting plan, there can be an urgent matter, such as a need for a financial decision, or maybe there's a summer camp needs to be decided, or there is a family health crisis, and the parents have not been able to work it out with the team, but it can't wait till the very end of the case. Then they can, either parent or any member of the team can call for a court conference. Then I, the judge, would hear what the issue was, try to help them come to consensus, and if not, make a quick decision on a temporary basis. And that decision would hold until the case was over. It would be usually incorporated into the final decision.
My name is Oran Kaufman. I'm an attorney and mediator. I have a private mediation practice, primarily mediation these days, in Amherst, Massachusetts. In addition to sometimes acting as mediator or attorney for the children, I also act as team coordinator. The team coordinator in Frisk is responsible for basically keeping the process moving forward. I mean, there's a lot of other things going on, but the team coordinator is responsible for scheduling, making sure that there are regular team meetings continuing, responsible for making sure that everybody is on the same page in terms of the schedule, who's supposed to do what. As a team coordinator, what I'll do is I'll create minutes after each meeting in which we say, here are the tasks that need to be completed, here are the dates that they need to be completed by, and then I'll follow up with people. In addition to that, as team coordinator, I'm responsible for running the team meetings. And when I say team, I'm talking about everybody, the parents, the family consultant, the mediator, the attorney for the child, and the attorneys, if they're attorneys for the parents. So I facilitate the team meetings and basically am the go-to person if there are any problems that we have not anticipated. So in terms of tasks and who does what on our team, so there's the family consultant, and the family consultant basically is the person who is working with the parents on the parenting piece. In addition to trying to help them resolve their issues, or problems that are coming up, there's also a psychoeducational piece of it where the family consultant may be helping them understand what's going on for their children or their children's developmental stage. And then again, helping them with the parenting plan and issues on that arena. The mediator is often the person who, as again, a neutral, is helping the parties deal with the financial issues, whether that be division of property, child support issues, anything that's really the financial end. Sometimes there may be overlap between what the mediator is doing and the family consultant is doing. And so as team coordinator, one of the things that I would do is make sure that there's no overlap and that the two of them know kind of what lane they're in and what they're each doing. In addition to that, there is the attorney for the child. And the attorney for the child is essentially the voice of the child in this process. There may be times when there will not be an attorney for the child, like maybe if the child is an infant. But that's something that as part of the process, there'll be a discussion and decision about by the parents if it's not necessary or appropriate to have an attorney for the child. And then in addition to that, there are the parents, obviously. Sometimes they both have attorneys, sometimes they don't have an attorney. One of my roles as team coordinator might be if there's somebody who has an attorney in the process and that attorney doesn't quite get how Frisk works, then it may be my job to sort of talk to them. There's an orientation at the beginning where new lawyers to Frisk will have an orientation to really explain the process to them and make sure that they understand how different this is than sort of the more traditional legal process. One of the nice things about being a team coordinator, and one of the interesting things about Frisk and what I like about this is that I'm working with different people every case. Every case is different. Unique things come up that we need to deal with. So it's not always going to be the same family consultant. It's not always going to be the same mediator. It's not always going to be the same attorney for the child. And obviously, parents are going to be different every time. Lawyers are going to be different every time. So it's really the team that we talk about is really a different team almost in every case. And that's a challenge, but also makes it interesting.
One important aspect of the Family Resolution Specialty Court that might not be obvious, but I know is of great concern to the judges, it is that the bulk of the work goes on in the team meetings. The judge is available if there's an issue that needs to be addressed or if there is an emergency that comes up that needs judicial input, and certainly the judge is available at the end if needed. But the bulk of the work is done among the team members. I would say that as a judge in the Family Resolution Specialty Court, I do less work in the courtroom per se, than I do in traditional cases because there aren't frequent motions and pretrial conferences and lengthy trials. But when I'm in the Frisk Court Conference, it's very hands-on. It's not that I sit back and listen, it's that I'm engaged with the family and with the team members, which I believe most judges who do this work, family court work, will actually find very satisfying because you have a very positive role and you can really help guide people in a way that in the more traditional role, you're just a receiver of information until the very end, but you can get right into the issue and talk to people and ask questions. In all types of courts, the system relies on a majority of the cases settling. And that's because we couldn't possibly try every single case as a contested matter. And so sometimes in the traditional system, the judge's role is quite limited in that process and is very formal. But in the Family Resolution Specialty Court, from the very, very beginning, a judge can begin to participate in helping the parents come to a settlement. The judge can come up with new ideas that other people haven't thought about. The judge can ask questions and have a much more active role. And that is a very satisfying function.
I'm Dr. Patrick Fleming. I'm a licensed psychologist and a licensed marriage and family therapist, and I'm a family consultant with the Frisk program. As a family consultant in the Frisk program, I do, I guess, a lot of different things. I feel that in some ways I'm the greeter at the door of Frisk. In the guided interview, I'm kind of the first staff person that the parents interact with. And so I want to bring them in and orient people. Things that qualify an individual for being a family consultant are credentialing, having a mental health license, either at a doctoral level or at a master's level as a social worker, and then awareness of the legal system, and having some pretty solid foundation and understanding of how the legal process works. The ability, I think, also to work with a team and to collaborate with people from diverse professional backgrounds. I interact with the various members on the team, including the lawyers, if parents have them, with the mediator, with the child's attorney, which is a particularly significant role. I interact with them from the beginning in the team, of forming the team, of trying to be transparent with them, of what I've seen, such as in the guided interview, which is, again, the first kind of contact with the family. So I usually have a lot of information and maybe questions from there, and that I want to maybe give the various team members a heads up. If there's particular issues about mediation, then I'm going to talk with the mediator. And again, in a transparent way, it's not talking behind the family's back. Good afternoon. I'm Dr. Fleming, Patrick Fleming. Please call me Patrick. I don't know if you remember, we met in the intake interview when you were considering coming into Frisk. I'm sure there are things that brought you to this point where you filed for a divorce that haven't been easy. What we want to focus on here is moving forward and, looking at the present and the future, and also, supporting you having a respectful and frankly kind of business-like post-divorce parenting relationship. Mm-hmm. Can I ask you, because I don't know your daughter, and unfortunately I'm not going to get to meet her probably in this, can you tell me just a little bit about her? I'd like each of you to tell me a bit about Tori.
Sure, and I'd like it, if I could speak without being interrupted by my wife, would be very helpful.
It's important that each of you, and one thing you may want to do is address everything to me at this point, but to listen carefully to what the other parent is saying, okay?
Sure.
So, David, you kind of started. Why don't you go ahead? Tell me about Tori.
Sure. Tori is a wonderful 11-year-old girl.
Okay.
She's extremely bright,
Uh-huh.
does very well in school, is interested in lots of different things.
Okay.
And the divorce is obviously hard on her. And one of the concerns I have is just that her mother is very, I would say, almost overly focused.
Oh, okay.
On,
Can I stop you there again? I want to hear as much as possible about your daughter first, and then I want to
Sure.
hear from Renee about
well,
your
our daughter
daughter.
is a very good ice skater.
Oh, okay.
And so good that she spends almost every weekend either training or at competitions. And that's something that Renee, her mother, is, I would suggest, maybe overly involved in.
Well,
and
okay.
trying to
Again,
kind of-
let me bring you back to okay. So Tori, it sounds like she's really talented as a
is.
skater.
She is.
And you also said she has a number of other interests and does well academically.
Absolutely, but her mother won't really
Oh,
allow her
okay.
to
Okay. Let's
explore those
okay.
interests.
Okay. Let me hear from Renee about Tori. Okay.
So
Tell me about your
Tori
daughter.
is just one of these kids that, lights up a room. She just is a pleaser. She's very articulate. I mean, she's only in 5th grade, so when he says she's so bright, I mean, come on, it's 5th grade. But there's no reason she wouldn't be bright because she has bright parents. But she is, what I love about her and what all the teachers talk about, and if you went to some of the teachers' conferences, you would hear that, like, she's the favorite of the teacher, that she's kind. If someone's having a hard day, she'll go up to that child and even offer them, like a snack from her lunch. She's just a wonderful child, and I think it's really important for her to continue with her skating, which she just loves. She just is. It's just almost like a gift from God the way she
So I'm getting the picture just from the brief time each of you talked about Tori, that she's a pretty well-rounded young person. I mean, she's got, does well academically, even though it's 5th grade, but still. And I like the way you said that she has 2 bright parents. That's nice that to recognize that attribute that each of you are contributing to for her, and the thing about her skating too that she's developed it, and it sounds like that's above and beyond just a kind of casual recreational kind of skating.
Oh, you'll see her in the Olympics.
Okay.
Well, okay. See, that's part of the problem.
Okay.
Putting that kind of pressure on our 11-year-old daughter is unfortunate.
How do the two of you typically communicate?
Text
Messages?
Yeah.
Okay.
He doesn't want to talk to me.
Phone conversations don't go well right now. I think things are too raw.
Okay. All right. And tell me, how long have you been separated now?
6 months.
6 months. Okay. So you've continued mostly texting, right?
But it's really hard to text. It's because sometimes he doesn't respond, and I need a response within a certain amount of time, or sometimes there's something he doesn't understand that I didn't text right, or I didn't say something, and I think it'd be really helpful to learn how to communicate with each other.
Okay. Well, there's a couple of things to that. Go ahead, David. You wanted to add something?
I mean, if I didn't get 23 texts a day, I would respond.
Okay.
That is ridiculous.
All right. Okay. All right. Okay. I'm going to give you a guide that talks specifically about, ways to text and email one another, kind of to give some structure to that. I'll give you that as a reference, and then in a subsequent meeting, I'll talk with you more about what you think about that, how that might work as we move forward in Frisk. I'm getting an idea, again, your concerns for Tori and your investment in her well-being. I want to clarify a couple of other things so that we can start to plan, and I'll tell you as we wrap up today what the next steps are going to be.
So the Family Resolution Specialty Court is a voluntary process, but we do have some screening. And when we first started, we felt that we should absolutely not have any domestic violence cases or cases in which there was a history of domestic violence in the Family Resolution Specialty Court, because we were so concerned about power imbalance, or somehow the less formalized process being a tool for an abusive parent against the other parent. And interestingly, very early on, we heard from some domestic violence advocates that they didn't want to be excluded automatically, that in fact it could be very empowering in certain situations, particularly if there were lawyers involved, but because the team is, it actually provides a kind of buffering between the parents, and can look for ways for this family, because there are children, to go forward without victimization and without abuse. So we have tried, when it's been appropriate, to have cases as well where there may have been a history of domestic violence. It's important that people can participate meaningfully. And so if a person is so compromised by substance use disorder or by mental health issues that they can't participate, then that person, a family, could be screened out. And sometimes if the family is just so high conflict that the ability to speak to one another in non-adversarial ways and the ability to be transparent about sharing information is just not within their skill set, then they really are not able to participate as well. This is a process that's not for everybody, just as many things in life are not for everybody. And we want to be sure that it's available to those who can make the best use of it and find it helpful for their family situation. But sometimes people are in the process and for any reason, they feel that it isn't right for them. And it is completely voluntary. So if either parent wants to opt out, it leaves the Family Resolution Specialty Court and goes immediately into the traditional track. A different judge will hear their case from that point forward, but if the Family Resolution Specialty Court judge has made any interim decisions, like a financial one, that will hold until the other judge, the traditional judge, hears the case and may change that or may just continue it.
My name is Diana Velez Harris. I am an attorney for approximately 20 years, specializing in family law. I am a mediator, a conciliator, and am trained as a collaborative law attorney. I am a mediator in the FRISC program for quite some time now. Probably the most rewarding work that I have done as a mediator, quite frankly, is to take part in the FRISC program. So I describe mediation the same way, whether it's in FRISC or not. Mediation is an opportunity for parents to meet in a far less formal setting to work together to come up with a solution to whatever the problem is at that moment. It allows parents to take control over the method of communication, take control over the setting that communication takes place, and it empowers them to resolve their own conflict on their own terms. I describe it as a safe place, a place free from judgment, a place where they can have a certain level of confidentiality relative to the communication that happens in that setting. And I believe that it provides them a great deal of comfort to know that what is said in the room essentially stays in the room unless they agree otherwise. In FRISC, it's the first time that you get a real team mentality. It is a team. We all have our specialties, and we're all all-star players on this team. And so if there's a gap in knowledge, there's a team member who can fill that gap. And if there's not, we find somebody who will. That's not how litigation works. That's not how litigation is structured. Generally, the only time parties see each other in litigation is to fight over a motion in front of a judge where they're giving up all control to let a third party who doesn't know them, their family, their children, their needs, except for a 10-minute presentation. FRISC is the opposite of that. FRISC attempts to avoid that altogether by having all of these different players help this family figure it out on their own. Help the parents figure it out on their own, because nobody knows their children's needs better than they do. Nobody knows their needs better than they do. And what I oftentimes tell people, it is horribly presumptuous of me to presume that I know the solution to your problem, especially when it involves your children. You don't have that same opportunity in the traditional litigation method. It's just not there. And so that's the reason why Frisk is so rewarding and I think so necessary. I think mediation allows parents especially to learn a new way to communicate after the court case is done, after the immediate conflict has resolved. Mediation with the help of the team members, it's not just in mediation, but really all components of the team, help parents learn how to effectively communicate when you're no longer an intact family per se, or when the immediate conflict that brought you to court resolves. There's inevitably going to be additional conflict and additional issues that arise in just raising children. And so as a result, in the process of mediation, the goal is to help parents learn how to communicate in a more effective way, a more respectful way, so that after this immediate conflict, they're able to have that communication to resolve any conflicts that arise in the future. The focus is less on me versus you and more on us versus the problem. And I think that's key in Frisk, and I think it's key in mediation as well. I attend the court conferences, I attend the team meetings, but my communication with the parties is confidential unless the parties agree otherwise. And so I certainly provide updates to the team as to the issues that are coming up in mediation. I involve other team members when appropriate, such as the family consultant, when issues surrounding co-parenting and communication come up. But my job within the team setting is really to meet with the parents, oftentimes alone, or generally alone, sometimes involving different team members, depending on the issue that comes up. Sometimes we'll have the attorneys for each of the parties join. If it's a child-related issue, we would have the child's attorney join us. The family consultant would oftentimes also join mediation sessions when we're having some difficulties relative to a parenting schedule or methods and ways of the parties communicating with each other to avoid any future conflict. And Frisk keeps the focus on, it's not about you or you, quite frankly, it's about them, the children, the little people that you created. And so the idea that the whole team is working together to keep the focus on that, because 9.9 out of 10 parents, all they worry about and all they care about is their children. That's the most important thing. So to continue the focus and continue to reinforce that the focus has to be on that, it's very easy common ground. And you may disagree on what's best for your children, and that's understandable. Intact families do too. But Frisk allows you to have those discussions in a healthy way, in theoretically a non-combative way, with the same common goal. Let's figure this problem out together, rather than me breaking you down so I can figure out the problem on my own. It's a shift in mentality, and the lovely thing about these court conferences is that the first question is, let me see a picture of your children. And there's no better way to center the thought process for the parents, to think about your children before you say anything negative about the other parent. That's an immediate shift in the mentality. You see people's faces light up in a courtroom, which is not often, when the picture of the children come out and they tell a quick little story about what their children did this weekend. There's no better way to center people than to do that. Good morning, David and Renee.
Morning.
Good morning.
So as a reminder before we begin, I know we've met already earlier once, we talked about the rules during mediation, but as a brief reminder, it's very important that we not interrupt each other. Very important that everybody have the opportunity to communicate how they feel on any particular subject that we decide to speak on, that there be no name calling during this process. And again, I want to shift our thinking to focus on possible solutions, airing those solutions, more brainstorming possible solutions. We don't have to necessarily pick one today, but I think brainstorming possible solutions could be really helpful to resolve these issues.
Because this is all about Tori, right, our daughter, isn't it?
The focus is absolutely on Tori. You both love your child dearly and want the best for her. And it's a matter of figuring out how we can get there in a way that you're both comfortable with, because this is 100% up to the two of you. So which one of you wants to begin by sharing with us what the concerns are relative to Tori's skating in particular?
Yeah, I mean,
Well, it's not really the skating. I thought we were talking about just the finances all around, because Renee just keeps wanting more and more money. and there's only so much money to go around.
It's not for
in
me,
this
it's for
family.
Tori, it's
So
for
if
your
we
daughter.
could, so
not
if we could
interrupt,
just not
please?
interrupt each
Well, it
other.
seems like he's taking a lot of time.
I
and-
promise, Renee, I promise you that I will give you the opportunity to respond. I promise you will have ample opportunity to speak what you'd like. If you'd like, take some notes as to some comments you want to make. I promise you I will give you the opportunity to respond.
Okay, that's fair.
Thank you. Okay, David, go ahead. What were you saying?
So, well, I was just going to say that we didn't have a lot of extra money when we were living together as a family. And now that I've moved out and have an apartment for me and Tori, there's even less money to go around. And so we need to, and I don't think Renee understands this, but we need to watch our spending because there isn't limitless money for me to hand over to Renee. I understand that I make more money than Renee does. And I'm certainly willing to contribute to our family to make things okay, but there has to be some kind of limit to how much I'm asked to pay.
Fair enough. And I think everybody would agree it takes more money. You can't run two households on the same income for one household. So it's definitely more challenging.
Mm-hmm.
And that's a big challenge that you're both facing right now, it sounds like.
Yes.
Okay.
Did you hear that?
And so Renee, Renee, I want to hear your thoughts in response to what David just said.
Tori has been skating like before she even like crawled. I mean, she's been on an ice skating rink, and to take this away from her, she's destroyed. This divorce is destroying her.
So I have a question for you, or I have a question for both of you.
Mm-hmm.
Does everybody agree that Tori should continue skating?
Absolutely.
Yes, nobody's talking about taking anything away from Tori.
Okay, I think it's important that we all focus on the fact that both of you are on the same page relative to Tori continuing her competitive skating.
Absolutely.
Is that fair to say? Okay.
Within reason. And so my suggestion would be that Tori's expenses for skating, which includes very expensive skates, lessons, some costumes that maybe Renee doesn't make herself, but we actually have to purchase. And it seems to me that we should agree on a number each year that we think is appropriate to spend on that, and then split that number in half, and we each pay half.
Half.
So
I'm
hold
a
on one
preschool
second. Hold on
teacher.
one second, Renee. So I want to make sure I understand what you're suggesting. You're comfortable paying the presumed amount for child support, which is $500 a week.
I am, and
And
I'm actually
above
offering
that.
to pay more
Okay.
towards Tori's activities that she predominantly does actually with Renee.
Okay, so let's talk about what that cost is, because I think before we can talk about splitting that cost, we need to be on the same page about what that is. Because it sounds like, Renee, that you kind of take the lead on a lot of this ice skating
Right, but
expenses.
even $500 a week, I'm not going to be able to stay in our house.
So let's
But that's
first
the law, that's what we have, that's what we're dealing with.
get on the same page about what these expenses are.
I'm not going to be able to make it.
Do you want to take a moment?
Yes.
It's okay to take a moment if you need it. We can take a break.
I mean, I could make extra hours if he's willing to take care of our, Tori. She's 11 years old. She should not be alone. Could you take care of her on Tuesday night?
course
Because
I
there's a
can.
family
Of
at
course.
preschool that I could, take care of their children and make some extra money. Are you willing to help?
I would like to have our daughter as much as possible. That's
Okay.
never been
And you will
that's
commit
never
that?
been-
You can't decide, John called and I want to go play
So Renee,
tennis.
let him answer your question. I think that's that's a great idea, thinking outside the box. I think that's wonderful. So it's my understanding, Renee, that what you're proposing is that if David were able to care for Tori a couple of times a week, more than he already is, that might allow you to create another stream of income for yourself. Is that
Exactly.
fair?
Yes.
And how do you think that extra stream of income might be helpful to resolve the issue relative to Tori's skating costs?
Well, if I had that extra money, then I could pay half of her expenses.
And David, I believe that was what you were suggesting might be a good resolution.
I think that would be a good resolution, yes.
It's okay. I think it's important that we do focus on the fact that there has been a lot of things that have been agreed upon today. There's been great out-of-box thinking and suggestions as to how we can resolve this. David is willing to take advantage of more parenting time, to allow Renee, you to take on this part-time job as a nanny, to come up with alternate source of income, to continue to support Tori and what we are presuming to be her dream.
Sounds great. Thank you.
You're welcome. Thank you.
The lawyers in the Family Resolution Specialty Court have a very, very special role in that they are absolutely key to helping the parents understand what the possibilities are, what their rights are, but to really focus on their needs. And also, if they hear something from the opposing party that actually makes sense, they don't see it as their job to tear it down or to somehow exclude it from the judge hearing it, but instead to put it into the mix as something that we're all talking about and thinking about. We've established the Family Resolution Specialty Court so that it is available and is helpful not only to people who both have lawyers, but also if one person has a lawyer or if neither person has a lawyer. In our court, a good percentage of parents in general, not just in the specialty court, but in general don't have lawyers. And so we're able to work with people who are self-represented. And when there's one lawyer on one side and no lawyer on the other side, that is often a very difficult situation for the lawyer, feeling that he or she has ethical constraints from talking with the other party or asking questions. But the team really supports that lawyer and supports the self-represented parent as well, so that that kind of free-flowing conversation can still happen.
My name is Jessica Berrien, and I am an attorney who practices family law, and I have been practicing for over 20 years and involved in the FRISC program for, I'd say, around 5 years now. When I describe FRISC to clients, most of them are really excited about this as an option. They would prefer not to have to file for divorce and start a traditional process. A lot of them would really like to come to a resolution with the other parent. They just don't know how. And so we're giving them the opportunity to be part of something where we say, listen, you have a team and we're gonna all work together in a collaborative process to hopefully get you an outcome that works for both parents. And I think that most parents feel relief that there is something like this that they can be a part of. When we come to the end of the FRISC process, I would say the majority of my clients are quite happy with the process. They felt heard, and I think that's the number one thing that I've heard from clients, that they felt like they had a voice. They were able to speak up and express themselves in many different venues, from mediation to even meetings with the judge, where typically a party wouldn't really get to speak very much to a judge in meetings or in court sessions, but they get to say things about what they feel and what they think is important. And I think that most of my clients are happy with that. They're also happy that they are able to work something out with the other parent, and they can take ownership of that. And there's something very satisfying about not having someone tell you how to be a parent, but making a decision how to be a parent with the other parent, and doing that in a collaborative process. I would say that parents who go through the traditional process often feel unsettled or perhaps a little more unhappy with the results. My take on that is because often it's going through attorneys only, and there isn't a lot of collaboration where they get to speak and talk things out and maybe figure out where some of their differences are coming from or how they can work together. So they're either being told by the court, this is the decision and you have to live with it, or even if they come to an agreement, it's usually mostly between the attorneys, and the parents are not very involved in that process. And I think there's a disconnect that makes it difficult when they're finally finished. How do we now go on being co-parents for the next 10, 15, 20 years when our attorneys did all of the work and we had no work together? There are some attorneys who have never been involved in a FRISC case. There are even some attorneys who don't know what it is. And so if you recommend that their client be part of FRISC, they may be hesitant. And so I think it's wonderful as a community to try to educate and open up this process to more attorneys so that they'll take advantage of it. I've worked with people who have never been an attorney in the FRISC process, and what we try to do as practitioners that are in the process more frequently is educate them, but not
but in a kind way where we're trying to show them how this process works. It may be frustrating sometimes for a new attorney because we don't do the same formalities in the process, and it's a little bit different. And I'd say most of the attorneys that have just started this process at the end are really happy with it, and I see them coming back with other clients. So I think it works well.
My name's Alan Sharp. I'm an attorney. I practice in Amherst, Mass. I've been practicing for 35 years, and I'm a child's attorney in the Family Resolution Specialty Court. My main job is to give the child a voice in the process. Initially, I like to talk to the parents alone to try to find out what the family's needs are, to try to get an idea of what the rhythm of this family is. And then I set up my first meeting. And that first meeting is with both parents together at hopefully the marital home with the child. It is really a process to get the child comfortable with me. In the next meeting, I might just talk to the child about what their interests are, sports or extracurricular activities or whatever it might be, so that I really want to get to know this child. Still, the second meeting, not even talking about the case at all. And then the third meeting, by that time, I usually get a pretty good sense as to whether or not they've warmed up to me. And that's when I can start to talk about the case and the divorce and the reasons, that I'm there to help them just as their parents have helped. Sometimes we don't give children the credit that they deserve. Children are there's a depth I have found to children that is really, really incredible. If given the opportunity, they even young children, 7, 8, 9, 10, 11 years old, they have thoughts that sometimes adults can minimize. But I find in this process, that when they do warm up and they start to give me their thoughts on their parents and sort of the stresses that they're under and what they'd like to see or whatnot, that they're much deeper than we as adults would even imagine. Everything that the child and I discuss is confidential. And I tell the child that. Not at the first meeting, not at the second meeting, because there's nothing really. But when we start to get into the crux of things, I let the child know that everything that we talk about is confidential. And unless they give me the express permission to discuss it with the group or their parents, whoever, then whatever they say to me stays with me. The biggest challenge for me is not substituting my own judgment. Like anything, this has been a learning curve for all of us. We all go into these cases. Every lawyer, every participant, every person goes into these cases with their own biases. I was raised a certain way. I have a family, and I've raised my children a certain way. It's hard not to go in these cases substituting what you've done in your life raising your children for this particular family.
So one of the challenges of having an interdisciplinary team is that lawyers and mental health professionals and lay people, as we refer to all human beings who are not lawyers or mental health professionals or mediators, all speak different languages. And often they don't understand one another. And so one very important focus of the Family Resolution Specialty Court has been to have language that makes sense across the disciplines and also is not burdened down with legalese, not only because it's often hard for a person who's not a lawyer to understand, but also because the language also often carries with it a negativity that we really do not want people to feel. So we don't refer to the parents as the parties. We don't say plaintiff and defendant. We don't say mother versus father. We say the parents. And when the papers are filed in the Family Resolution Specialty Court, in the court, it's the parent's name with an and between them, because they will always be an and to their children. And we do that in every way, every time there's an opportunity to step back from formal language, like it's not a motion hearing, it's a court conference to discuss an issue. It's not a trial, it's the final court conference. It's not cross-examination, it's questions of clarification. And these might seem small, But when you put it all together, it creates an environment that, that makes parents feel that they are really part of a process of healing and growth themselves, as opposed to going into an alien world. One challenge that judges might face in shifting to do the Family Resolution Specialty Court, or really any specialty court, is leaving the extremely formal role as a judge. You don't sit a long distance away from the people and their lawyers. You don't sit at a higher level than they do. You are really needing to be present in a very active way throughout the entire court conference. Sometimes being a judge is a very passive thing, that you are listening and taking notes and kind of formulating what you're going to say or what you're going to write. But with this, you're in the moment with all the members of the team, and it's a shift, and it takes some energy. I wouldn't recommend doing your family resolution specialty case as your last case of the day, because the more energetic you are when you go into it, the more you'll be able to both give to the team and to the parents, but also the more rewarding it'll be for you, because you'll find that people do look to you as a judge with experience and with the wisdom and the knowledge that you have in your position, but that you can also be a human being to them. And that's a very wonderful experience. The other challenge you might find as a judge is that lawyers have been trained to be zealous advocates, and sometimes that it doesn't translate that well into being a lawyer in the Family Resolution Specialty Court. We provide training to the lawyers so that they learn how to participate in a different way, remembering that zealous advocate doesn't just mean being harsh to the other side, but it means thinking about the family down the road and how important it is for the parents to be able to communicate about their child in the long term. The other advantage for the parents, and also to some extent for the judge, is that the rules of evidence are looser in the Family Resolution Specialty Court. There is precedent for looser rules of evidence. For example, in our domestic violence cases, those are typically looser evidence rules, which doesn't mean that the rules of evidence go out the window. It just means that it's a little more flexible in people being able to say what someone else has told them, which would normally be excluded because of hearsay, and therefore you'd need to bring in that person to testify. But the level of trust, even with the cases that end up being contested, has been built between the parents, between the lawyers, within the team, so that they're far less edgy about having to insist on the rigid rules. And they're much more willing to allow information to come to the judge in a more collaborative fashion. The court conferences are, to the judge at least, the heart of the Family Resolution Specialty Court, and that's because we really don't have much to do while the teams are working. But typically, the parents will choose this particular way to proceed with their case. They'll meet with their team, and we'll have the first court conference. And then it can be a few weeks, it can be a few months, depending on the complexity of the issues. We'll have a second court conference. Sometimes that is the final court conference, because in all of that period between the first and the second, which can be weeks or months, the team's been meeting, the team's been working, and the parents are able to come up with an agreement. And then we would have our final court conference as the second one. And I always have a final conference to essentially thank people for choosing us, and also to congratulate them because they've managed to resolve their family issues without going into an adversarial mode. But sometimes we need more than those two conferences if the team is not able to resolve everything together. And so there'll be a planning conference. And that's where we talk about what will we need in order for the judge to make a decision. What issues are left that are unresolved? What pieces of information will need to be exchanged? Who's going to speak at the final court conference? How long will it take? And then it's usually not very long between that planning conference and then the actual court conference. And I would say in terms of amount of time or duration of conferences, first court conference is not even a half an hour, maybe 15 minutes. The middle one can be more like an hour or longer, partly because the judge will generally jump in and try to help resolve the issues that are out there remaining. And sometimes they are, and then that can be the final conference. Or the judge is trying to do scheduling with everyone. And then the final court conference, it really varies, but the longest one that I had was a case where one of the parents was moving out of the area. And these so-called removal cases are very difficult because there can't be exactly a shared parenting schedule. And one parent always feels like they're losing because the child's going to have to go with the other parent. And that one took a few hours. And if you think about a typical removal case, that can go on for days. And so it's a much more efficient use of the judge's time because throughout the course of the other court conferences, I've been able to learn from the parents why the removal is happening, what the bases are for it, and to ask lots of questions along the way. And I can use that information in the final decision, which again is a little different than the much more formalistic trial, where we're really just taking the evidence that we're getting on that day, as duplicative as that evidence can be. So we're back together again, and I know you've had a lot of team meetings and conversations since we were last together. So I'm going to ask the team coordinator, or Ron, could you just tell us where we are today?
Yeah. So when we first met, both Renee and David talked about how they were really willing to work hard and wanted to work hard in this process, and they have. We've had a lot of team meetings, and I just want to applaud you for how well you've worked with the team.
Thank you.
Yeah.
So then actually, Patrick, why don't I hear from you about what's happened with respect to Tori and her schedule?
Well, Your Honor, Renee and David have worked very hard. I think from the very beginning, they've recognized the idea of keeping Tori out of the middle of things and wanting to both be very involved in her life and to move things forward for her, to provide support for her. They're concerned about her being overscheduled with the skating and other things. We've started to put into place the idea of Tori seeing a school counselor rather than looking for a counselor outside school, for a number of reasons, but it may keep her schedule as simple as possible. David and Renee have also done some really nice work around their, recognizing their communication issues and starting to implement some ways that are more effective and, kind of developing a good business-like co-parenting relationship as they communicate.
Good. Well, you're to be congratulated because that's the biggest part of your lives is your girl, so good. And so Kathy is mediator. So you've been working with them, and how's that going?
Renee and David have worked really hard in mediation. So in the mediation session, the biggest concern financially on the support side had to do with the costs of the skating expenses for Tori. I got educated on that and learned that what they've been spending to date for her per year is somewhere in the vicinity of maybe $7,000 to $10,000 a year. They talked about various options as to what they might do and settled on leaving the child support according to child support guidelines, and as an added expense, sharing 50-50 the skating costs. Renee has been looking for something else but hasn't found anything. She's been unable now to commit to paying that 50%. So that's really the issue that they're bringing before the court today to you.
Well, commend you on getting as far as you did, and I'm sorry that solution wasn't one that worked for you both. It sounded like we could have had this as the final court conference, but for the nanny job falling through. So are you going to continue to look for a second job, Renee?
I haven't. I just, after mediation and going through my budget and trying to figure this out, even if I, could make a little more money, like paying 50% I just can't do it. So I was hoping we could figure out other creative ways to figure out how to get more money and for David to pay more.
So what are your thoughts about it, David?
I'm a bank manager and I've reached a ceiling. And I've agreed to pay the full amount of the child support that I'm expected to pay. And on top of that, I have agreed to pay for half of what is a very expensive extracurricular activity for our daughter. But Renee doesn't work full time. I work a full 40-hour week and she works about a 25-hour week. And I do think that there are other things that our daughter could maybe be interested in or focused on.
Your Honor, she does love ice skating. There's no question about it. But there is also a little bit of an underlying tension. She does feel the pressure of Renee's push a little bit. So for her, she's trying to figure out at her age, how much she wants to go forward and how much of it is that she wants to do it for Renee. And so I do think that, Renee and David, the court needs to just be sensitive to the fact that we're dealing with a young child. And, she's got parents that have gone through a divorce. That's one traumatic event for her in her life. And, she's sort of feeling a little bit caught in the middle of, Renee's drive to do this with her passion for the sport. And also knowing that there's another world out there that her father would like to expose her to. And so, I would just ask, both Renee and David and the court take that into consideration as we're moving forward. She did want me to voice that.
Mm-hmm. Well, I never heard that, so I think that's really helpful to hear because she's never said that to me. So I'm willing to back off.
And she didn't look at it, and she doesn't want to hurt you. She loves you, and she knows how much effort you put into this, and she knows, you've given up a good portion of your life to take her on these things and the sacrifices that you've made. And she, she appreciates every single moment of that with you. She does. And so she doesn't want you to feel that you're underappreciated. But she is being pulled. She's being pulled by what I said previously.
One way to think about this is, first of all, I'm glad to hear she's going to see the school counselor. I think that's really important. Mm-hmm. But, this moment in time, as Ellen has said, is a very big one in her life. And it seems as though, at least for right now, she does enjoy the skating. She gets a lot of positive reinforcement. It sounds like she does really well. Maybe the thing to do is not to think about this in a, sort of a open shut way, but to say for X period of time, whatever the next skating season is, we will commit to making sure it's the best experience possible for her, and then we'll look at it again.
Are you suggesting, Judge Fidnick, that we keep the case open and come back together in a few months?
What I would do, because this is very time sensitive, because we've got to fund her one way or the other, to have everybody work together in mediation. But what I'll do today with everyone, with your permission, is to set out what the final court conference would look like, who would testify, or we don't call it testify in family resolution especially, but who would speak, what materials I would have to see. I'd really love to see all the cost breakout and things like that. So does that make sense, so that you don't feel like you're on a long string at all, but that we'll be working together. Final court conference is just that. It's not a trial. You're not going to be put on the stand and cross-examined. You're going to be able to tell me, each of you, with the assistance of your lawyers, everything that you think I need to know to make a fair and Tory-focused decision that will not be so onerous to either of you financially. But I need to know if you want to have anybody talk to me at this last conference other than just the two of you. Sometimes people want other people, like maybe Tori's coach, maybe her counselor. Then there will be questions for clarification that could come up. So you might say something, David, and then Gail might say, for clarification, David, can you tell me this, that, or the other thing? Not to trap you or make you feel bad, because Jessica will do the same. It's really to make sure that I have all the information that I can possibly have to make the right decision.
That sounds great.
And Alan disclosed information today from Tori that he obviously had the permission to disclose to the group, and it was very significant information that the parents, both parents, I think, but certainly Renee, is going to have to think a lot about. And if there's a counselor involved here helping Tori think about her choices that she now has open to her, whether to continue with skating, at what level, whether to add some other kinds of activities that she may love. But maybe now that her parents know, she can maybe even talk with them about it. Mm-hmm. And if they need some help learning how to talk with her about these new ideas, the team would be ready to help with that.
And if you do reach a resolution, then all your lawyers need to do is get in touch with the TC, and we'll come in and do an uncontested final hearing. So, Jessica, you were concerned about time, and I wanted to be sure that everybody understood that the timing of this will be very much driven by what your needs are and the family's needs. And so we'll probably schedule this for 2 hours in the afternoon at some point. And I will leave it up to Oran as the team coordinator to work with you and with the clerk and the registry about when to do it. All right? Good. Well, thanks, everybody. So I think we've done what we can do today. And once again, nice to see you, Renee. Nice to see you, David. Thank you, team. Doing a great job. Always a pleasure to work with the Family Resolution Specialty Court.
Thank you.
Hi, I'm Dr. Marcia Klein-Pruitt. I'm the Maconda Brown O'Connor Professor of Social Work at Smith College, and also I'm an adjunct in the Department of Psychology. One of the things that I really want to advocate for today is not to take evaluation too lightly. It's easy to think about cutting it because you really need all of your energy and your resources and your money to get a program started. But by evaluating it from the beginning, you have the chance to see, first of all, what it is you want to study. And there's plenty of research on bias that shows us we're invested in these programs. So we're going to find that they're helpful by researching them. And it doesn't have to be big research. It doesn't have to be fancy research. But even in little ways, by knowing what it is you want to study, you know what it is in the program that's important that you want to target. And then you know what is working and what's not, so that you can make things better. I talked about doing a pre and post comparison. So the kinds of things that we are going to be examining in Frisk and that we already have been examining are adjustment, parents' adjustment in terms of their own anxiety, the quality of their parenting. In particular, we're interested in the quality of their co-parenting, their conflict, their cooperation, and their communication. And then we're interested in the child's outcomes, because all of this is really focused on the children. We're doing this to improve the life of children after divorce. So we're interested in what children's behaviors are, and we're interested in what children's adjustment to the divorces. At this point, it makes sense to tell you a little bit of what we've found to date. First of all, when we asked people who had not been in the FRISC process what their experience has been in family court, we found that most people were negative, and a number of people were neutral. They either said, we did what we had to do, basically we went through it, or we got a whole litany of information about how the court process was biased and it was long and it was expensive and people hated it. Compared to that, people who were in the FRISC program, overwhelmingly, almost 3/4 of them reported that they were very positive about the experience. Now, that's especially important because there is nothing positive about going through the legal system to get a divorce. It's not like going out to a movie. It's never going to be a positive experience. But the fact that so many people reported that they felt supported and that they felt positive about it, more than 83% of them said that the staff had just been there for them, had answered their questions, had given them good resources, and given them good service. Also really interesting, 78% of them said that they got what they really needed. 73% of them said they got what they wanted. That's 5% who were able to realize that what they wanted may not have been the same as what they needed. That is what I call success. We also did a lot of open-ended questions to ask people to tell us what they thought about the process and their experiences. It's what you call qualitative research. One was communication and conflict. They wanted to talk a lot about that. The second one was personalization, how personalized the experience was. The third one was child advocacy, the extent to which they felt the process took care of and advocated for their children. And the last one was about resources and time. I'm not going to talk a lot about those 4 categories, but I will tell you that most of the positive responses across all the categories came about child advocacy and conflict and communication. People felt that their child was advocated for. They gave us quotes that said that they felt like their child remained in the center of the process, that they weren't forgotten in the conflict, and that it wasn't a lot of adults fighting over kids, but that their kids' face, voice, and presence remained throughout the process. The second thing was conflict and communication. Some people learned communication skills. We didn't expect a lot of that because it's a short program and you don't learn that kind of skill in a short time. But people picked up on skills and they felt that they could talk to their partners and they felt that they were co-parenting in a more positive and in a more consistent way. Most of the program recipients said they would recommend the program to other people. And they not only recommended it, but they came out in the strongly recommend category. They talked about how the FRISC process felt like a team process instead of a battle. And parents these days really get that. Most kids are involved in some kind of sport, and teams are a very big part of how kids think, how they learn, and how they spend their time. The fact that FRISC was viewed as a team process where people were not pitted against each other, but they were figuring out how to work together, that models for parents that even people who have different perspectives or come from a different place can work together for the sake of their kids. So they both observe it, they learn it, they hear it, and eventually that message takes hold. In terms of very specific information, people reported that their co-parenting communication increased, their acrimony decreased. They felt that their outcomes, that their co-parenting and their parenting were more positive. The last thing I want to say that was really important, I think, to our FRISC team is that parents felt that being part of the process reaffirmed for them the importance of putting their child first and really centering their child's well-being. And they felt that the process walked the walk.
I hope you've enjoyed watching this video about the Family Resolution Specialty Court. We've been helping families with this since 2015, and we have many success stories. We have materials that we would love to share with you. We will come train you if you would like us to come visit. We can do it by video or by Zoom. And we hope that this has inspired you to bring a program like this to the families in your community.